Good morning and welcome to the Court of Appeals today. We have one matter on our oral argument calendar, and that is State of Utah versus Spencer. And I am Michelle Christensen Forster, the presiding judge of the Court of Appeals, and I'm joined on the panel today by my colleagues Gregory Orm and Judge John Luthi. And we will hear arguments. I think you've both been here many times before, so I don't need to tell you about the clock or anything like that. I see that you've reserved 3 minutes for rebuttal, Ms. Townsend, and if you could both please enter your appearances for the record.
Yes, my name is Melissa Jo Townsend for the appellant Derek Spencer.
Marian Decker for the state.
Nice to see you both. Just the one reminder that I'll give you, just to re-enter your appearance when you take the podium, just because we're streaming, and then it will make it much more clear as to who is speaking. And if you don't have any questions, please begin when you're ready.
Madam Presiding Judge, and may it please the court, Melissa Jo Townsend for the appellant Derek Spencer. Derek Spencer's motion for a directed verdict should have been granted, and this case otherwise should be remanded for a new trial because he received the ineffective assistance of counsel. I'll begin with the directed verdict motion. A trial court's ruling on a motion for directed verdict should be reversed only when the evidence is sufficiently inconclusive that reasonable minds must have entertained a reasonable doubt as to any element of the charged crime. That element in this case is Casey's age at the time of the alleged sexual activity. And the trial court's ruling here should be reversed for two reasons. The first, the court applied the wrong legal standard, and second, the evidence was sufficiently inconclusive as to how old Casey was at the time of the sexual activity.
If the trial court applied the wrong standard, and the state at least concedes that the wrong verbiage was used, our review is we still review for the legal conclusion, right? Whether or not the directed verdict should have been granted is a question of law that I think we can review non-differentially. Am I wrong about that?
You're right about that, Your Honor. This is a legal question. Embedded within that is the legal standard the correct legal standard that should have been used and relied on by the district court. But because there was a legal error, it's compounded by the factual analysis that precedes a legal analysis, or precedes the legal conclusion about the directed verdict motion and whether it should have been granted. So certainly, while it is a legal question, there is a layered effect with the wrong legal standard that was used in this case.
I get to how that would perhaps explain what happened below, but if we step back and apply the correct standard and look at the record and review it as a question of law, if we conclude, well, the court conceded that this was really kind of a close case. He had some concerns about the completeness of the evidence as it bore on age, but nonetheless concluded, and the state nicely summarized, Ms. Decker, in about the first 3 pages of the red brief, cobbles together a pretty good explanation of how, if you draw all the right inferences and put all the right pieces together, there is evidence there to establish the fact that at the time of the sexual encounter, she was only 13. Now, I've been in the business of Monday morning quarterbacking for some few years now, and so I hesitate to say this, but it's part of my job description. It baffles me that the prosecutor would not just have said, and exactly how old were you at the time of the sexual encounter? That's just weird that didn't happen, in my not so humble opinion. But what is the flaw in Ms. Decker's explanation of the pieces that were before Judge Coram that allowed him to say, yeah, I've had some concerns about this, but if you draw the right inferences and have the right sequence of events in mind, there is evidence before the jury that would sustain this conviction.
So for that, I'll run briefly through that cobblestone of dates and information that we have. And I'll also point this court to page 382 of the record, which I think is very important for this exact question. But so we know 2 dates with certainty. The first is that on August 30th, 2022 is when they had the trial, and Casey was 18 years old at the time of trial. We don't know if she had turned 18 that year or if she was turning 19 that year. Beyond that, we also know that Casey went to the doctor on May 25th of 2018. And in terms of chronology, we know a couple of facts as well, that the sex preceded the doctor's visit. We know this because she went to the doctor fearing that she had an STD. She testified to that effect on page 374. We also know that the sex preceded one of Casey's birthdays. This is on page 382 of the record that she testified to that effect. Now, the last piece of information that we know about this chronology is that Casey had a birthday, and this is where I'll quote on page 382 of the record, in between the time, well, around the time that she went to the doctor, maybe a little bit before that. So in between the time, around the time that she went to the doctor, maybe a little bit before that, there was also a birthday. Importantly, we don't know which birthday this was, that she was turning 14 or if she was turning 15.
Can I just interject? You said earlier that we don't know if in August of 2022, she was 18, still going to turn 19 in 2022, or if she had already had her birthday that year. Don't we know that she'd already had her birthday that year if she testified that around May or a little before the appointment in May was her birthday? Don't we know that her birthday is in the first quarter of the year, or the first half of the year at least?
So that is the indicative question, Your Honor, of this is the prosecutor's question. I'm trying to read it just verbatim exactly. She does say yes to it, but what she's saying yes to is a compound question of in between the time, around the time that she went to the doctor, maybe a little bit before that. She says yes. There's no follow-up or clarification regarding when her
And I
birthday.
guess my follow-up would be, we're still talking about May 25th. And if we're talking about around that time, between that time and the sexual encounter, or a bit before that time, none of that puts us anywhere close to or after August.
Well, Your Honor, we don't have Casey's definition of around that time. She says elsewhere in the record too that she thought at one point about how her birthday was coming up. We don't know when she was thinking that, but it could be coming up, and I think your definition of coming up and my definition of coming up might have some discrepancies in the exact amount of time that phrase encapsulates. Now, what's important to remember is
So
Casey
you're suggesting it could mean it's coming up, and this is to a 14-year-old, it's coming up in, or I guess an 18-year-old at the time she's testifying. It's coming up in 3 months.
It's coming up.
More than 3 months.
It's coming up that summer. I think it's as simple as that. My birthday is coming up in that regard, and I think the important thing to remember is that there was no clarification from the prosecutor, and so whatever conclusion we are drawing from her answer that is derived from that question, we are filling in some information there that was not explicitly provided to the jury, that was not clarified by Casey or the prosecutor. We are speculating as to what exactly she meant by her yes and what exactly the prosecutor meant by asking that question. Now, she could very well have been turning 19 the day after trial, August 31st of 2022, which would have put her at 14 years old, turning 15 during the entire events in question in 2018.
Can I bring you back just a little quickly to our standard of review? Even if somehow the trial court's articulation of the directed verdict standard as prima facie evidence, even if that did lower sort of the burden of proof, sort of piggybacking on Judge Orm's question, on appeal as a question of law, we will uphold a trial court's denial of a motion for a directed verdict if viewed in the light most favorable to the state, some evidence exists from which a reasonable jury could find that the elements of the crime have been proven beyond a reasonable doubt. And I know that the trial court and the briefs on appeal, there is some evidence that exists that Casey was 13. And isn't that enough to sustain the verdict in this case?
No, Your Honor, and the reason is because just going back to this conversation that we're having here, what we're doing is moving beyond the realm of inference and into the realm of speculation. And when we're in the realm of speculation, that means that we're in the world of reasonable doubt. Now, if I can just direct this court's attention to page 1134 of the record, this is during Derek's sentencing hearing, but it provides some important insight, I believe, as to what the court would have done had it applied the correct legal standard. Just about 2/3 of the page down, the court says, "There is no doubt in my mind this event actually happened. The doubt, I suppose, creeps in as to when it happened." In the next paragraph, incredibly, the state never even offered evidence of what her date of birth was. That was the first question the jury had in about 2 minutes from getting back there, and the question I was wondering the entire day, how old was she? So from here, the court explicitly states that there is doubt as to when the sexual activity happened in relation to her birthday, when her birthday was in particular. Now, looking at that and then looking at the jury who asked the question of when Casey's birthday was, that indicates that in this chain of logic, we have a critical piece of information that's missing. And for this, I'll point the court as well to State versus Hershey. We have a very similar procedural and even factual, or not factual, but certainly procedural background in that case. This was the case we noticed in our 24J letter
I
to that.
appreciated having a chance to review that again. I had kind of forgotten about that case, but that was an interesting read, although I didn't see the factual similarity between that case and the case at hand. I mean, yes, it talks about the standard of review, but the facts are very different there in terms of inference and so on.
If I may just connect those dots for you, Your Honor. Paragraphs 20 to 23 are those that are most important to this case. In that case, by means of factual background, we have a series of crimes that were charged, and we have an essential element for one of them, and that was whether skin-to-skin contact had been made between the defendant and the victim. There was undisputable evidence that the defendant had put his hand down the victim's pants, but there was a question still of whether skin-to-skin contact had been made during that action. Now, importantly, this court says in paragraph 22 that there was an absence of direct testimony about skin-to-skin contact. That's what we have here. We have an absence of direct testimony that Casey was 13 years old at the time of the sexual activity. Now, in that case, there was also a lack of evidence regarding what type of underwear the victim was wearing. And this argument that the state was making on appeal in that case was that skin-to-skin contact was unavoidable by virtue of the fact that the defendant put his hand down the victim's pants. But that conclusion would only be reasonable based off of that missing piece of information of what type of underwear the victim was wearing. Because if she was wearing spandex, it would be, the skin-to-skin contact would be different if she was wearing that versus a G-string. Now we have the same lack of information or lack of evidence here. We know that she had a birthday coming up, but we don't know if it was her 14th birthday or her 15th birthday that was coming up. We also don't have any direct or circumstantial evidence that would help us make the inference that she was 13 years old based off of what her birthday was, because we also don't know what her birthday was. Now, those two things coupled together is a break in our chain of logic. And when we are stacking inferences, inferring from the question that the prosecutor asked that she indeed had a birthday before, in order to get us to the inference that she therefore was 13 years old at the time of the sexual activity, where we stack inferences like that, that indicates we're in the realm of speculation and we are in the world of reasonable doubt. my time is over. I'd be happy to talk about the other issues if this court has questions about them.
I interrupted you when you were about to say exactly why page 382 was key. What was the key language that you were going to refer to on page 382?
I was just trying to flag that is the page in the record where the prosecutor asks about Casey's birthday. And so we have the question there that indicates some sort of relationship between her birthday and the doctor's visit, as well as her explanation about her birthday coming up.
Thank you.
Looks like there are no other questions. Thank you very much for your argument, Ms. Townsend.
Yes.
We'll see you in a minute.
Marion Decker for the state. Regarding the denial of a directed verdict motion, there was at least some evidence from which jurors could find beyond a reasonable doubt that Spencer had sex with Casey when she was younger than 14. We don't have to prove, the state didn't have to prove the date the sex occurred or the date of Casey's birth date. Neither of those are elements. But we can draw from the testimony and the dates that we do have, the reasonable inference that she was 13. And at this point, that is the standard of review. And that is, we view the evidence now in the light most favorable to the verdict that the jury made. And to the extent that there were ambiguities, they resolved those ambiguities in favor of finding that she was younger than 14 when the sex occurred. And so from the dates that we've discussed, we know that Casey testified at trial that she was 18 in August 2022, which, if you relate that back, it would make her 14 in August of 2018. She testified that she went to the doctor on the 25th of May, 2018, quote, with some parts missing, longer than 1 or 2 months after the sex occurred. So that puts the sex in the first quarter of 2018, at the latest in March of 2018. And then she also testifies that the sex occurred before her birthday because she knew, she remembered knowing, quote, knowing that it was, quote, coming up. And that's at page, I have different record citations. I think there are 2 copies of the record, so 977, 976, 977. And then Casey testifies that her birthday was, and this is where the prosecutor asked that question. I want to talk to you just briefly, this is in my record, 976. So in between the time, well, around the time that you went to the doctor, maybe a little bit before that, did you have a birthday? And she responds affirmatively. So that's around the time, maybe a little bit before she goes to the doctor in May of 2018, and we already know that she's testified the sex occurred before her birthday, which she knew was coming up. So it's reasonable to infer that Casey's birthday was after the sex and occurred sometime, but sometime before August 2018. In other words, she couldn't have been 14 when the sex occurred because she would have turned 15 shortly after the sex occurred. And if that were the case, she would have been 15 in August 2018 and 19 in August 2022. But we know she was only 18 in August of 2022.
So the jury asks specifically, what's her birthday? And the judge says, you need to just decide this on the evidence that you have before you with reference to the instructions. So you don't think it strains credulity to think that the jury went through this same exercise that you take us through in the first few pages of your brief, which I found a quite compelling explanation. You think the jury could have replicated your work, and I guess in that regard, they were out for a few hours, right? This was a one-day trial, a 4-day, or 4
One-day
hour-
trial.
One-day trial, 4-hour deliberation. Is that more or less right?
I'm not recalling off the top of my head. I know that the trial court has gone through this in denying the directed verdict motion, and there's no reason to think the jurors were not as capable of walking through that. They'd also heard argument objections during closing argument and the prosecutor explaining, okay, it's not the dates that are so important as much as the chronology in which things happen. So they've already been introduced to our analysis. And yes, it takes some thinking, but jurors are competent people. There's no claim that they aren't, and they weren't capable of putting some head work into this. And when you do, these are the reasonable inferences. And we now resolve any ambiguities in favor of supporting that verdict. That's the standard of review.
Can you remind me, the question included the phrases around the time, a little bit before, and in between, and there's not a statement, that part isn't complete. We don't know exactly in between what. I think we can infer, but what was that, were all of those in with reference to the doctor appointment
Yes.
around the time that the,
It's the birthday in relation to the doctor's appointment. That's what's being discussed there.
that the
It's when is your
so the
birthday in
birthday
relation
is
to the,
around the time, a little bit before, or in between something.
right, a little bit before you went to the birthday, and she says yes. She doesn't say, no, it was just after. She says yes. And so the jury any ambiguity there, the jury's drawn in favor of the birthday happened after the sex and before August, because we know that she's already 14 by then, and we know that she went to the doctor longer than 1 or 2 months after the sex, so we know the doctor is in late May, so sex is in first quarter. She
I get
also
that. It
testified.
seems to me like this kind of comes down to how much you can stretch that phrase around the time. Can around the time of May 25th include into August? Is that a reasonable read of around the time?
Even assuming that were a reasonable read, it's a reasonable read that it's closer in time and maybe a little bit before, and that is the read that the jury drew, and that is the verdict favoring inference the court must now draw. To the extent you have questions about that, the jury resolved those ambiguities in favor of the birthday coming after the sex and the doctor's appointment coming after the sex, but before, and the birthday coming before August of sometime. It sounds like to me substantially before August when she's saying, I know it's coming up and I'm wondering how he's gonna feel about that.
I'm not sure that, in my mind, that's an ambiguity that we just leave to the jury to resolve. And I didn't think of this analogy till right now, and so maybe it's a bad analogy. But if it was a murder case and the testimony was, well, I saw the victim lying there with his eyes closed and he didn't appear to be breathing, do we leave it to the jury to resolve the ambiguity of whether he was dead or asleep?
Well,
Or do you say that would be speculation?
well, again, I don't know the other facts that the jury would have in your case, but here, and I admit, if we take one of these inferences away if we take one of these dates away, maybe we don't have enough, but we have enough here. Trials are not perfect. We have all seen that. I mean, yes, it's shocking that the prosecutor didn't ask the date, but trials are fluid things. None of them are perfect, but we have enough. And we know how old she was when she testified. We know that the thing that she affirms includes a little bit before. She doesn't correct that. A little bit before, around the time, to me, is closer to May, or a little bit before, closer to when the sex occurred in the first quarter of the year that she's turning 14. She also testifies that it's cold outside. She doesn't want to escape out the window when he tells her to. And that also aligns with first quarter, January, February, March 2018. And the jury is drawing all of those inferences from the information, the direct testimony that they do have. Sustainable verdicts, we uphold all the time on the basis of circumstantial evidence. We have the trial court also comments at sentencing that this is the most credible testimony he's heard, one of the most credible witnesses he's heard. There's no question that this occurred. It's all about the date. And yes, the trial court was peeved that neither side was as prepared as he would have liked them to be, but there's enough evidence here, and the jury drew those inferences to reasonably conclude she was younger than 14 when this sex occurred. And now this court must view those ambiguities through that same verdict favoring light.
What do we do with the prosecutor's admitted erroneous sort of supposition, or, well, it wasn't just a supposition, it was written down in the demonstrative exhibit during closing, that the sexual intercourse occurred in January 2018. I mean, that's not a fact in evidence, right? That is speculation. And how does that influence ultimately the jury's verdict?
Well, again, I would disagree.
Okay.
We can know from the, no, January didn't come into evidence.
And the
but we
court
c-
struck that.
And the court
reference.
struck it, yes. And the jury was informed that's not in evidence.
look
And
at
that's
that.
when the prosecutor says, okay, the dates aren't as important as the chronology. Follow the chronology. And it's not speculation, because the state's theory is that is when the sex occurred. And when you look at the dates and the evidence that we do have, you can draw that inference that it occurred. The sex occurred in the first quarter of 2018, which includes January. And the latest it would have been is March. So it's not entirely speculative. It just, that fact itself was not admitted. But again, that doesn't undercut the inferences that we can draw from the dates and the testimony we do have, that the sex occurred before her birthday. And we can triangulate that it must have been the year she's turning 14 from the other information that we have. And that's what the jury did.
I have a
Good,
question.
good use of triangulate.
I have a question about the 23B motion, and the first, the fact that the defense would like to put into the record about the affair, and whether the declaration accompanying the motion is sufficient to be not providing speculative facts, but anyway, the sufficiency of the declaration regarding the affair.
Regarding the affair. Even if it was not inadequate, which I believe it is, reasonable counsel can reasonably conclude it's not going to do his client any favor to call his own mother to testify about this drama in the family. She has an obvious bias. I mean, that's defense 101. It's not going
I
to serve.
understand that, but I'm still interested in the question of whether the affidavit, or it's not an affidavit, but the declaration, if we did feel like that fact would be enough that it could support an ineffective assistance claim. Why
Well,
is
there's-
the declaration not sufficient?
There's no indication that the mother influenced the allegations here. I mean, there's no, other than that affidavit of the mother of the defendant opining that this is what motivated this, that's all there is. And it seems a far stretch, and even if it were, counsel could not want to wade into that territory for very reasonable. It's not going to look good in front of the jury. They could be annoyed, they could find it tawdry, and it could be victim blaming. There are a lot of reasons that you don't want the mother of the defendant on the stand talking about this.
Thank you.
If there are no further questions, I will ask the court to affirm.
Thank you, Ms. Townsend. Ms. Becker. Ms. Townsend?
Your Honors, Melissa Jo Townsend for Derek Spencer, the appellant. 2 points I'd like to make on the record here. First, just piggybacking off this 23B motion, I just want to point out that if we buy into that reasoning, that just because of the biological relationship between Derek and his mother, that his mother's automatically not credible, or it's automatically reasonable for counsel to not investigate her explanation and what she said in her declaration, then that bars every family member from ever testifying in defense of another family member. And I think that that conclusion is unreasonable. And it's unreasonable under these circumstances provided, or that we provided in our 23B motion.
Isn't there a sort of assumption wrapped up in that, though? And isn't it the defendant's burden to demonstrate that there was a lack of investigation, or at least a lack of pursuing this maybe potential line of defense by defense counsel? Doesn't on appeal, and in order to receive a remand, don't you sort of have to show that there was, that this issue was ignored by defense counsel? We can't just presume that, correct?
Meaning that we would have to have a declaration from trial counsel. Certainly, in my read of Rule 23B, there's no requirement that we have a declaration from trial counsel, his or herself. I think the rule doesn't require that because that can be a difficult thing to obtain in every case. But what we do have is a declaration, and Rule 23B allows us to read that in light most favorable to the defense, and it allows us to get a remand so that we can supplement the record with adequate information to prove an ineffective assistance of counsel claim. The second point I want to make is, while I understand that on appeal, we need to look at the evidence in the light most favorable to the jury verdict, we do need to look at the jury's verdict with exactly what Judge Christensen Forrester pointed out, and that is that there was an informational gap in the chain of logic that was presented to the jury. The jury identified it. It knew that it needed Casey's birthday in order to make the inference, the critical inference, that was going to put Derek behind bars and look at a 25-year to life sentence instead of something much, much less than that. Going off of Judge Luthie's example with, or hypothetical about the murder case, when we venture into that realm of looking at the jury's verdict in the light most favorable, we need to remember that at least in this case, there are other circumstances that are pressing on that verdict. And in particular, our second issue, the prosecutorial misconduct issue, where the prosecutor repeatedly is leaving information or leading the jury to make conclusions that are not supported by the direct evidence or even the circumstantial evidence. My last point with that I'll make is that the exhibit that was discussed, January 2018, was objected to and was stricken, but there was a parenthetical next to it that said age 13. That was not objected to and not stricken.
Doesn't all of that, though, rise or fall with whether we think there was evidence in the record that could support that she's 13? Because if there is evidence in the record to survive the directed verdict, then the prosecutor can use those same inferences in arguing the facts at closing.
Yes, Your Honor, the prosecutor can make those inferences, and you identified the exact question that this case hinges on. It's on page 382 and also elsewhere in the record, but the exact language is, so in between the time, well, around the time that you went to the doctor, maybe a little bit before that, did you have a birthday? The question before this court is whether reasonable minds could differ as to whether Casey's yes to that question conclusively shows that she had a birthday before the doctor's visit. And if
or close to the time, right? Because even if it was a few days later in May or the first part of June, that still works with her being 18 in August, that we'd know that the birthday that's being referred to is her turning 14 birthday and not her turning 15 birthday, right?
Yes, Your Honor, close to the birthday.
So we'd have to say that as Casey listened to that question, she disregarded a little bit before, in between, presumably, doctor's appointment and the encounter, and she somehow didn't hear either of those, and she only heard a little bit around and thought, yep, and a little bit around includes 3 months later. And even though that's a warm time of year, and it was cold closer to taking all those facts, we'd have to assume that, yep, Casey only heard the one part of the question and read it and interpreted it quite broadly in terms of time, right?
We'd have to, whatever conclusion you or I make about that, we have to understand that Casey, that conclusion is coming from us and not from Casey, not from her testimony. It could be that she turned 14 the previous August and was coming up on her 15th birthday that summer. And just the important thing to remember is that however you and I read that question, we are reading into it and thereby by reading information into it, we are making a conclusion that's not what Casey said in order to get to the inference that she was 13 years old. And it's that stacking of inferences that is the problem here. For these reasons, we'd ask this court to reverse. Thank you.
Thank you, Ms. Townsend, and thank you, Ms. Decker. We will take this matter under advisement and render a written decision as soon as we can. Thank you for your good argument today, and thank you for your good briefing. Appreciate it. Makes our job easier.